the criminal justice system. He asserted that the new laws will focus on nyay instead of dand, that is punishment. Also, instead of delay, there will be speedy trial and speedy justice. So what are the provisions in the new laws which make them victim-centric and justice-oriented? What steps are being taken towards their effective implementation, and what role will technology play to help transform India's judicial system into a modern one which is in sync with the current times? We'll understand all this and much more with two very distinguished guests who join us on this edition of Perspective. I'm pleased to welcome in the studio Mr. Suresh Chandra, former Law Secretary, and joining us virtually is Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University of Law. He's joining us online from Hyderabad. Professor, delighted to have you with us in the studio as well. So together with the two of you, we'll try and understand all the key provisions, the significant changes that they will bring about in India's criminal justice system. But before that, an audio bite of the Union Home Minister on the day when these three criminal laws came into effect. Listen it.
देश की जनता को सबसे पहले मैं बहुत बहुत बधाई देना चाहता हूं कि लगभग आजादी के 77 साल बाद आपराधिक न्याय प्रणाली, हमारी क्रिमिनल जस्टिस सिस्टम पूर्णतया स्वदेशी हो रही है और भारतीय इथोस के आधार पर ही चलेगी.
Okay, so let's take it from there. Mr. Chandra, your thoughts first on what the Home Minister and the government has to say. 77 years after independence, India's criminal justice system becomes indigenous, Swadeshi. How do you look at this overhaul of the colonial era code, both symbolically and qualitatively?
In fact, we have seen lot of reports like Malimat Committee reports, various Law Commission reports, various amendments during all these 77 years. But if you see whatever efforts were made, these were cut and paste and very smaller one. And these were not overhauling the whole criminal justice system, which has been done now. They have studied in depth, they have made wide consultations, and I am of the view, if I have to describe this in few words, it is an effort to rationalize, to organize, to consolidate, and also to simplify the criminal justice system.
Right.
And if you see in our preamble, what is there? Equitable justice, justice for all, as well as the unity, security and integrity of the nation. If you see, all these aspects are very prominently and very beautifully have been brought it, incorporated in this law. So I will give all kudos to those who have drafted, and some of the, when I use the word organizing the laws, how they have prioritized from the sedition or the acts, offences against the state, they have been relegated. What has been brought in and prioritized is the offences against the women, children, and justice to the victim, whether it is protection, whether it is equitable, this. And apart from that, I will say, not only the provisions of this Nyaya Samhita have been brought down from 511 to 358 odd. Okay. The rationalization and some of the deletion of the offences is also commendable, I will say. And most important, which I will say, the zero FIR as well as timelines which have been given very beautifully in the Nagarik Suraksha Adhiniyam. These are marvelous. And third thing is, incorporation or I will say use of latest science and technology or digital evidences, etc.,
Sure.
or forensic evidence. That is the most important.
So we'll come to the qualitative impact of these changes that the new laws will bring about in the later course of the program. But let me take your appreciation to Professor Rao, one of the members who was part of the drafting committee of these laws. Professor Rao, the fact is that legislative reforms were something long overdue, and everyone would agree that a lot of our laws, especially in the criminal justice system, had become obsolete. So there was need to bring about certain reforms. As someone who was part of the drafting committee, tell us and our viewers about some of the progressive elements that are embedded in these three criminal laws.
Yeah, Suresh Chandraji already has uncovered some of the progressive changes. Almost the three criminal major acts have been dominating the criminal justice system almost over 150 years. And now there is a comprehensive reforms have been visualized, and the government of India, particularly Minister of Home, started from 2020 onwards, and it connected into after 3 years of serious work, and then it has just come into place from yesterday. Firstly, it's not just only the introducing the Indian idiom Bharatiyata. I like the phrase Bharatiyata, and you could see the justice-centric and victim-centric witness protections being first time has been given a priority. Some of these suggestions and recommendations have been there pending with the government of India for many years, but a comprehensive reform has been visualized and implemented recently. Let me begin with saying that gender-neutral language for the first time. In fact, as a students of criminal law, and all of us as the criminal law teachers, we used to take it granted he means she. But the first time Bharatiya Nyaya Samhita introduced he, she and transgender. This is something which is amazing, because that sends a signal that the transgender women have been taken care, and the protection of women and children is an important priority in the Bharatiya Nyaya Samhita. Similarly, positive language and phrases have been used, because we used to unsound mind, idiot, these words we used to use. These are old colonial words, English words, and the new Bharatiya Nyaya Samhita introduced mental health and mental ill person, and based on the Mental Health Act. Similarly, if you look at, community service is an amazing. This is post-emergency Indian Supreme Court with Justice B.R. Krishna here have been advocating for the community service. So for the first time, community service is a reformation. Rehabilitation of the prisoners have started, of course, only in the petty offences. But we see in the future, this will be a major reformation goals. Maybe I am optimistic it will be extended to even other serious offences. And we have probation officers, one of the best unused segment in the criminal justice system. They will be more effective. I think we need to popularize community service, because we have seen prisons also have been overcrowded, and so therefore this community service is another important milestone, I would see. Similarly, decriminalizing the attempt to commit suicide. The Supreme Court said long ago, 309 Mithu versus State of Punjab, section 309, but this time the BNS not only decriminalized attempt to commit suicide, but also focused on ये जो suicide attempt करता है उसको we should treat as a treatment, rehabilitation. This is focus. I think that's something is very good, and I think I
You're
would
right, and
consider
perhaps
this
that's-
is a
perhaps
starting,
that's
a
the
major.
focus of this framework. I'll come back to you, Professor Rao, but the points that you've made, let me get in a word from Mr. Chandra in this regard.
Sure.
That the overall focus, Mr. Chandra, in that aspect is that we shift from mere punishment to nyai. So because the British era laws focus more on the punishment and not on nyai, that's the transitional shift that we will see through these laws. From the point of view of administration of justice, from the victim-centric point of view, and as Professor Rao cited the example of the victims of suicide, how significant is this transition?
This is, impact of this will be very huge on the society. Maybe it looks a very small amendment in the act, but if you see it will have an impact over a large number of people, as the victim centric, reformative, from the punishment to reformative or justice centric we have used. That's why the community services as well as what you call protection or sensitizing authorities towards the victims, these will go a long way in administration of justice. I see definitely once these things are implemented, you will see a lot of, initially there may be certain doubts, there may be certain hue and cry about the community services, even about the detentions, about enhancement of punishments, about, if you see overall, as I have understood these laws, these are very reformative and justice oriented, in tune with the preamble of our constitution.
Okay, Professor, I'll come back to you on the other aspect, and which directly concerns us, is speedy justice. It ensures that there will be speedy trials, there will be time-bound delivery of justice. That is what is very significant to the common man, especially when we are talking about a country wherein about 5 crore cases are pending at different levels of judiciary. How crucial does this aspect of timely delivery of justice become?
I think that's another very important, significant aspect in this Bharatiya Nagarik Suraksha Samhita. In fact, if I look back, the new criminal procedure code we call 1973, one of the important objective is speedy investigation and speedy trial. But we have not been able, even though the SICO has tried to push and then several reforms have been done, but BNSS, this new criminal procedure code, not only suggests speedy investigation, speedy trial, each trial completed within 45 days, the writing of the judgment. I think that's a significance, but of course it requires more of training the mass to change. The mindset of the lawyers, mindset of the judges, and everybody should see that speedy investigation important, because what we have seen, not only in criminal cases, but other cases where there is a lot of tendency, perhaps, and that is hindering the justice in the criminal law. So that's one aspect. Second, I wanted to say that as Suresh Chandra ji has pointed out, use of science and technology. Major thing is forensic science. We have been saying this for many years. If you look at the investigation should start from crime scene to criminal. But the old traditional methods, what we have seen is they will start with criminal to crime. एक आदमी को पकड़ लो and then मार दो and then you get this tendency, this mindset will change with BNSS, because forensic science is being given and a lot of emphasis is given in forensic science, and we have seen over the last 2 years the government of India, particularly Ministry of Home Affairs, has come out with the National Forensic Science Universities and propagating use of that forensic science. This is a right and opportune time for all the lawyers and everybody, judges, even the law schools, law colleges, they have established more and more more scientific methods of forensic science, understand and develop. Hyderabad is a major DNA fingerprinting started from the Hyderabad. So this is one big speedy investigation, speedy trial, and along with that, use of forensic science is a major thing. But we need to strengthen all the agencies of the criminal justice administration, and more, I know this year Government of India budget is also more focusing on forensic science, and we need forensic science units starting from district level, state level, and completely that science and technology friendly, citizen friendly system, I think, is started developing.
That's something, Mr. Chandra, which will ensure that these laws cater to the contemporary social realities and are in tune with the changing technology as well. But the question here is in terms of preparations to when the law was passed in Parliament and to the time that it came into effect on the 1st of July. We had ample time to prepare ourselves, and if I could ask you, you were at the helm, you were the law secretary, what are the kind of preparations that would be required at the institutional level? Social aspect is something that we will discuss because that will take a lot of time in terms of adapting to the change, but the fact institutional preparations are something which will be the first big step towards effective implementation.
Tina, first I should remind you, I retired as law secretary 5 years
But you know
back.
the procedure, sir.
Yeah, we know the procedure, the
Yes.
preparedness, and as Rao Saab has already told, and I was reading from the newspaper reports, the Honorable Home Minister has been emphasizing training the judges, the police officers, the forensic experts, all these. So preparations were going on. How long, how much, this only the authorities can tell. I'm of the view that the authorities are always prepared whenever any task or any challenge comes before them, whether this is police authorities or the judges, also they equip themselves. What is required is the change of their mindset, and the change of mindset will come from the training, from the orientation program,
Right.
and this will also come in due course of time through the media, information explosion or information which reaches to the people. As far as the implementation aspect will come, I mean, there will be certain hardships, but these will come definitely in the limelight, and definitely I am of the view with these preparedness, with the increase of the budget, we will definitely come out with proper implementation of these laws.
Okay, Professor Rao, because we're talking about the implementation and the need to adapt to the change, the fact is change is not easy to accept so easily, and especially if we talk about the social acceptance. And I'll give you one example. Section 420, it became a part of our lives, so much so that it became a synonym for somebody who would cheat. We would say, ye 400 BC kar raha hai. So how do we get out of that era, of that sections of the IPC that our generations have lived over for decades, to get to a more progressive system which has now been put in place?
Yeah. I know it takes some time to rephrase our mind and look at this. I think that's maybe a year, let's hope. I think 2-3 years, that's what even Home Minister has said. But somewhere the change has to start. Some beginning has to be done. I think that beginning has been done. We will understand. It will take some time. But the amount of the work which has been done, the intention behind is to create new laws. I think that purpose is solved, and training which is required, a lot of training is required. Already last 3 to 6 months, the several trainings have been done. We have developed for the National Police Academy. There is several online videos and other for the state of Telangana we have done, and several law schools are taking this. I think this is a right time to create the new mindset, and slowly there will be some gaps in the laws that may be slowly during the interpretation which comes to the court, that may be whatever the gaps may be overcome, but the capacity building, I think recently the government of India is also focusing on capacity building of others, and if all the bar councils, law schools, judiciary, police, probation officers, forensic science, all of them come together. The problem in the Indian criminal justice system is there is no concerted action of all the criminal justice agencies. So if all of them come together, make a comprehensive effort, naturally everybody learn. And now we have to already it has started the enforcement and implementation. So therefore everybody will be eager to learn. I will give one example. When Section 89 the CPC was amended, and I remember 1999 it came into 2002, that is introducing alternative dispute resolution. Many people were scared. No, they said no, it will not. Now you see, mediation, arbitration has given as an important aspect.
Right, absolutely. You're right, and the fact is, we've taken that most important step towards change, Mr. Chandra. Now the key will lie in effective implementation, and that's the most challenging part for the government. So over the next few months, few years to say, when everyone is ready to adapt to this change, and it's going to bring about radical change in our criminal justice system. How do you think the government will ensure that whatever is the objective of these three laws, especially the substantive bit and the procedural aspect, is taken care of in the limited time? Because given the fact that there are already lots of apprehensions, there are lots of concerns which have been raised. The Home Minister did try to allay some of the apprehensions, but the government's task is clearly going to be very difficult in the times to come.
Thank you. I remember Professor Rao has mentioned about the amendments in 1999. Which came into being in 2000. I was one of the person in drafting these laws, CPC and all. And there were a lot of objections, and these were challenged in the court of law, in the Supreme Court. Prior to that, first amendment we brought in by bringing in digital, electronic use of serving summons, etc. in under section 138 of the negotiable instruments, bouncing of checks. That was also certain concerns were raised. But in due course of time, if you see, everybody has accepted after the Supreme Court had okayed the CPC amendments and all those amendments which brought in these latest technologies and which brought in timelines. There were certain fears that it will adversely affect the independence of judiciary. These timelines will not give leverage to the judges and all. But in due course of time, if you see, everybody has accepted it. It was a reasonable thing.
Similar
apprehensions have been raised about the community services, about the custody, extension of the period for the custody. Though 15 days time is sacrosanct, and the Supreme Court has also said,
and that's something which has been clarified by the Home Minister.
Yes, that has been clarified. So these fears and apprehensions will continue, but what prevails, or what will have the reasonableness, the Wednesbury principle of reasonableness. What is reasonable is a man of ordinary prudence thinks, and that the law, if you go through this law, I don't see any of the provisions which is unreasonable to my mind. And as far as the implementation is concerned, authorities are bound to implement the laws made by the Parliament, and I am confident that they will implement in letter and spirit, and all these doubts and all these things will settle down in due course of time. But I don't say these will not be challenged. These will definitely be challenged, and maybe some what you call synthesis, anti-synthesis and synthesis will take place, and ultimately whatever will come that will be the best.
But trust the people of India to adapt to the change, because I remember similar apprehensions were made by people at the highest level regarding the digital payments, if you would recall. But look at how UPI has become a success story in India. It's something that has become a case study for several of the countries which now want to adapt a similar technology. So technology is not the worrying part, it's the misinformation on a lot of these laws which are being spread. So apprehensions are okay, which can be allayed and addressed by the concerned authorities, but misinformation is something that will prove to be a huge challenge for the government, and which the government will have to take care of. But having said that, time allows me to take up only that much on the program today. I'd like to thank Mr. Chandra and Professor Rao for joining us on the show today and taking us and our viewers through the importance, the significance of these laws and the kind of radical changes that they will bring about in India's criminal justice system. Thank you very much to you viewers also.